All right, let's jump right into this explainer and decode what is arguably one of the most critical foundational concepts in the entire Pakistani legal system: jurisdiction. Look, whether you're a law student cramming for exams, a junior advocate just starting out, or even a seasoned legal researcher, understanding exactly how and where to file a case isn't just about, checking boxes on a form. It is about protecting your client's most fundamental rights. Because if you get this wrong right out of the gate, well, everything else you do might literally just turn to dust. Here's our roadmap for today. We're going to cover the meaning of jurisdiction, the three jurisdictional pillars, the hierarchy of Pakistani courts, the specific roles of the High and Supreme Courts, and finally, fatal jurisdictional errors. Just keep in mind, while we're going to be looking primarily through the lens of civil procedure under the Code of Civil Procedure 1908, these exact same foundational principles closely mirror the broader legal system, including the criminal courts. Kicking things off with Section 1, the meaning of jurisdiction. Now, to really raise the stakes right off the bat, let's look at what this actually means in the real world. In the legal field, procedure isn't just a bunch of boring paperwork. It's the actual machinery that makes substantive rights real. And as established in landmark Pakistani jurisprudence, a judgment delivered without jurisdiction isn't just like a minor clerical mistake. It is a complete and absolute nullity. It has zero legal effect. In fact, it can be challenged at any time, even collaterally in later proceedings. And here is a massive trap that so many fall into. You absolutely cannot just agree to give a court jurisdiction by the consent of the parties if the statute doesn't already grant it. So even if everyone is getting along and neither party objects, a jurisdictionless proceeding simply cannot be saved. So what is it? Quite simply, jurisdiction is the legal authority of the court to actually adjudicate a case. Fun fact, the word itself literally translates from Latin as to speak the law. It's essentially the procedural bridge between a plaintiff filing a grievance and a court having the lawful, binding power to issue a decree. And without that authority, as we just saw, any order passed by a judge is, well, legally meaningless. And, this brings us right to Section 9 of the Code of Civil Procedure, which brilliantly illustrates this concept and really forms the absolute bedrock of civil litigation in Pakistan. Section 9 grants civil courts this incredibly sweeping inherent jurisdiction to try basically all suits of a civil nature. They are your default forums. But, and this is a big but, notice that crucial caveat at the very end, unless expressly or impliedly barred. We're going to see exactly how those bars work in just a second. Moving right along to Section 2, the three jurisdictional pillars. Okay, so here is how we break down the exact parameters lawyers use to choose the right court. It's basically a three-part test. Think of these as the three main pillars holding up your entire case. First, territorial jurisdiction. That determines the where, the geographical location. Second, pecuniary jurisdiction. This looks at the how much, the monetary value of the suit. And third, subject matter jurisdiction, which asks what kind. Basically, is this court even authorized to hear the specific type of dispute? Whether you're in a civil court looking at the value of a property or a criminal court looking at the severity of an offense under the CRPC, all of these parameters have to be satisfied simultaneously. If even one pillar cracks, the whole case comes crashing down. Let's ground all this theory in reality. Say you've got a practical hypothetical under Section 20 of the CPC, which governs personal causes of action like contracts. This is a scenario practitioners deal with literally all the time in commercial litigation. Picture this. The contract is signed up in Lahore. The defendant lives down in Karachi, but the actual performance of the contract happens in Multan. So where do you file? Well, in this scenario, the plaintiff can strategically choose to file the suit in Lahore, Karachi, or Multan. Why? Because Section 20 clearly states that a court has territorial jurisdiction where the defendant resides or works, or where the cause of action arose, wholly or in part. Since the contract was signed in Lahore, part of the action arose there. Performance was in Multan, so that's another part, and the defendant is sitting in Karachi. So, as the lawyer, you get to select the forum based on tactical advantages, like maybe procedural speed or favorable judicial precedence in one of those specific cities. That brings us to Section 3, Hierarchy of Pakistani Courts. Let's map out the actual playing field here. The golden rule of litigation? You must file your suit in the court of the lowest grade competent to try it. So starting at the bottom of the hierarchy, cases typically kick off at the civil judge level, ranging from Class 3 all the way up to senior civil judge. And where you land there depends entirely on the pecuniary or monetary limits set by provincial notifications. From there, appeals ascend the ladder. They go up to the district judge or additional district judge, which act as the first appellate court. After that, matters can keep ascending all the way up to the High Court and finally the Supreme Court, depending, of course, on your specific appellate rights. Now, here's a super important distinction to make. Remember that little caveat we talked about back in Section 9, the impliedly or expressly barred part? This is it in action. Specialized tribunals expressly or impliedly bar the jurisdiction of general civil courts. So if you've got a dispute over recovering bank finances, or matrimonial issues, or even specific anti-terrorism criminal charges, those specialized tribunals have exclusive jurisdiction. Like, if it's a matrimonial issue, you are going to the family court under the 1964 Act. Filing that in a general civil court when a specialized tribunal is required, that's going to result in an immediate dismissal, no questions asked.
Let's step up to the big leagues in Section 4, High and Supreme Courts.
As we ascend to the upper echelons, you really need to understand the distinct powers of the highest courts in the land, because the rules change pretty significantly as you move up. The High Court basically wears multiple hats. It acts as a first appellate court for high-value original decrees. It also acts as a second appellate court under Section 100, but, and this is crucial, only for substantial questions of law. It's not going to reappreciate all your factual evidence. And finally, it exercises revisional jurisdiction under Section 115, which is kind of like a supervisory check to correct the jurisdictional errors of subordinate courts without needing to go through a full-blown appeal. 90. I want you to burn this number into your brain. You generally have exactly 90 days to file a second appeal under Section 100 to the High Court. Time limits in civil procedure are incredibly inflexible, and they are calculated from the exact date the judgment is pronounced, not when the written decree is finally signed. Missing these mandatory limits, yeah, that can be absolutely fatal to your case. And sitting at the very apex, we have the Supreme Court of Pakistan, which functions as the final civil appellate authority. But here's the thing, it's not just a third tier for arguing over basic facts. Most appeals require leave, meaning the court actually has to grant you permission first, usually only for substantial questions of law of public importance. But under the Constitution of Pakistan, 1973, it also holds original jurisdiction under Article 184. This is reserved for massive, landscape-shifting issues like intergovernmental disputes between provinces or for the direct enforcement of fundamental rights. All right, down to our final stretch. Section 5, Fatal Jurisdictional Errors. This right here is the trap, the fatal consequences of making jurisdictional errors right at the starting line. What actually happens if you file in the wrong place? As a practitioner, you must master this difference. If you file in a court that just lacks territorial or pecuniary jurisdiction, the court will simply return the plaint under Order 7, Rule 10. That's just an order you literally take your paperwork and go refile it in the correct court. But if your plaint fails to disclose a cause of action or is barred by some law, the court will reject it under Rule 11. That is a fatal substantive dismissal. It acts as a full decree, and your only option at that point is to appeal it. Confuse these two, and you might just destroy your client's limitation period entirely. So, bringing it all together, will a procedural misstep cost your client their rights? Absolutely, because jurisdiction is the absolute foundation of every valid adjudication. The ultimate question you've got to ask yourself is whether your strategic choices will uphold your case or render the whole thing a complete nullity. The Code of Civil Procedure is definitely designed to ensure fairness, but I promise you, it is unforgiving to those who ignore its structure. So always, always verify your territorial, pecuniary, and subject matter jurisdiction before you ever step foot inside a courtroom. Because at the end of the day, if the law guarantees every citizen a remedy, what good is that remedy if you're knocking on the wrong door?